The writ petition has been dismissed, but there is another very important aspect, Mr. Bokulial. Your action is necessary. We have made a direction. While dismissing the writ petition on the grounds aforementioned, this court is intrigued by the fact that a passport claimed to have been issued in the name of the petition and so and so. This court fails to comprehend as to how a passport could have been issued in as much as prior to issuance of such passport, which is effective from 30/5/2013, the present reference was already pending. A mandatory prerequisite for issuance of passport is police verification. This court fails to understand as to how a favorable report could have been given in such police report when the aspect of the petitioner's citizenship itself was questioned by a reference. Considering the seriousness of the matter, where a proceeding facing a citizenship issue has been granted a passport, this court directs the Department of Home, Assam, and the DGP to cause an inquiry in the matter, cast responsibility, and take appropriate steps against the erring person.
Copy of the error may be served.
Obviously, you'll take. What is the review you are seeking?
Lordship, there is some error apparent on the face of the record, and subsequently we have discovered some two documents that
There are two different aspects. Error apparent on the face of the record, and you said that you have discovered subsequently.
No,
So which one are you urging?
both of them.
Both.
Both, Lordship.
Let us see. What is the error apparent?
Kindly turn to page 40, Lordship.
Page
40.
40.
40. Para 8, Lordship. May I read you?
Just a minute, please. Para 8.
Yes, Lordship.
What is it?
In the written statement, the petitioner categorically stated that his father and his grandfather came from East Pakistan and settled at Lakaipatti, Nagaon, and that his father obtained a certificate of registration from the deputy commissioner as stated above. He also stated above that the father has changed his place of residence of village Tangkhali in the district of Moringam. The petitioner further shifted to village Nij Mikirveta, and that he casted his vote in the year 1985. He also stated that his father voted in the year 1917, and that his father obtained certificate of registration by serial number 105/1968, and the registration number was 28781. Lordship, that registration certificate is 106/1968, and registration number was 287872, Lordship. And in first line, he stated that his father and grandfather. Grandfather, they never stated about that. His father came from East Pakistan.
Let us see the written statement.
Lordship,
Let us see the written statement.
written.
Have we enclosed the written statement?
Yes, Lordship, I have replaced. Page 87, Lordship.
87.
A. So
Father late Vaishnav Chandra Nath of the Dapaipatti. Grandfather had not come.
no, Lordship.
Okay.
His wife's grandfather came.
Okay.
But that by order dated 27.
Now, what material difference will it make in the decision?
No, because it should be corrected. Otherwise, if I will file an appeal also, then the judgment is not,
You want correction of this?
this also, and that certificate numbered also. That
Okay,
is,
that part only.
that part also. Then second paragraph 9 also, Lordship, para 9 of the judgment, page 42, Lordship.
Para 9.
9 of the, that is, it's page 42.
42, yes.
The learned counsel for the petitioner, Kayla Hopper, has submitted that the certificate of registering in the name of father who was exhibited in the case of his relative, and same could not be exhibited in original in his case. However, he submitted that the certificate in fact were issued by the administration. His father, he relied on the school certificate issued in favor of the petitioner, and in the said certificate it was stated that petitioner had attended his final exam of class 3, and that his date of birth was 31/12/73. He never stated about that his date of birth of 31/12/73. Only in the certificate, the date of he passed, that should be corrected, Lordship.
Let us see that certificate.
He passed.
Is the certificate, have you included the certificate?
Yeah, yes, Lordship.
Page?
Lordship, I would so. No, yeah, yes. Sorry, Lordship. Hey, to Sunday, Pallu. So, yeah. Inheritance petitioner. Sorry, no. Lordship.
Left.
Date of birth is 21
No. He left school on 31. Page 16 of the
Page 66, Lordship, sorry.
page 16 of the regulation. It is there.
Original page 67 in vernacular, Lordship.
67.
16. Page 68.
67.
No, page 16. 16.
16.
Of read condition.
No, দেখানো না। আচ্ছা আচ্ছা
31/12/74. He left the school.
Date of birth was not there.
But can you read this for us, the vernacular, madam?
It is a page 67 vernacular.
Please read it for us.
Radhesham Nath, Pita, Bৈষ্ণব Soran Nath, Lordship. Mikiri Beta, so 1973, Sonor December Mahot. Hikka Kek Hoy. It is not so legible that it is very difficult to. And তৃতীয় শ্রেণীত পৰা পৰীক্ষাত উত্তীৰ্ণ তেওঁৰ শিক্ষা শেষ হ'ল। এই বছৰৰ এই
31/12/73.
তৃতীয় শ্ৰেণীত তেওঁৰ সেই পৰীক্ষাৰ উত্তীৰ্ণ হয়। স্কুলত থকা কালত তেওঁৰ চৰিত্ৰ ভাল। 1973 চনত তাৰিখত তেওঁৰ 72 চনত তেওঁৰ বয়স 10 বছৰ 6 মাহ।
Oh, this is become transfer certificate.
He passed class
School
3
certificate again.
in 1973. Is
In the translation copy, you had yourself written 74. 31/12/74. It should be 73. You check the records of the writ petition. Page 16 and 17 of the writ petition. Page 16 is the vernacular, and 17, this 31/12/1974 has been stated. It should be 73 and
73, Lordship.
these are to
Another Lordship, Lordship has stated in the page, para 16, 11, that certificate of registration was not placed that time. But subsequently, we,
No, the certificate of registration was placed in another case, the original.
another, but now we have received that, Lordship, the original
Now you
one.
have received.
Yes, Lordship. From his another brother. I have mentioned, stated in my repetition, Lordship.
But then that will not be a new fact. You had
But
already.
that was not considered. That is why, Lordship,
now what is the final direction here in this case?
Lordship,
Giving you liberty.
with liberty,
Okay. Now we can make it, we can clarify that that certificate, you can place it before the authority for consideration. For the interest of justice, that can be done.
Lordship.
If you have the original now,
Yes, Lordship.
we can just give a
That
direction
was
as a
proved
direction.
that was proved in another case, Lordship, related.
In
to-
fact, this is not a application, where it's application, rather a miscase for correction of certain inadvertent errors.
and,
If not in the decision making process, there will be no change.
and
so-
produce the original documents
Okay.
that is the registration certificate that is obtained in 1968 by
Okay.
the father of the
Yes, yes,
petitioner.
yes.
In this paragraph 9 that you have
Yeah.
shown, there the school certificate was considered and you are showing transfer. It's same, right?
A school, that is transfer certificate from one school to another.
Any other school certificate was there?
No, thereafter he is not prosecuted for the study, Lordship.
Believe nine.
Not he final examination to course, you know.
এখানে আছে,
He
60
attend-
page 60 No note to আছে তাই।
ভুলকে লিখিলো না।
Okay, we'll pass this.
Written statement, Lordship will observe in the paragraph, page 27, paragraph 16, that written statement did not mention about the earlier case of the relative. At that time, the judgment was not passed, Lordship. Opinion was given on 24/6.
No, not on the passing of the judgment, on the pendency of the reference case.
Yes,
That is also not reflected in
that
this.
is because he has filed a written statement earlier to that, Lordship.
No,
Subsequently, in his evidence, he stated about that.
not the judgment part. The pendency of the reference, that also was not reflected.
In evidence, he has stated.
That is correct. This part will correct it.
I am mentioned in my page.
That's paragraph 2, paragraph 1. Date of birth is not the date of birth, the date of leaving school in paragraph 9. And the grandfather, he did not. Grandfather or grandfather is offense. See, the statement page 87. No? No, father and grandfather is also there. That is not get it, but still then factual correct. Date of birth is correct. I will not research now. This is they can tell you. Discuss that. Speak that we will see. Okay,
Lordship, and another one, page 109. That is-
109.
Yes, right. Voter list of 1985, where his family member's name has been reflected. Mother's brother.
What is the finding here?
No, only single voter list was submitted at that time.
That this is a new document.
But I have received that from
No.
my brother, Lordship.
This we are not considering. Documents which have been subsequently procured after the judgment, those in certiorari jurisdiction we are not. This will not be a ground of review.
For that, I have to approach higher court only.
This is not a ground of review. The others, yes. Others, yes.
I have stated in paragraph 20, page 24, Lordship. Grounds.
Okay. Mr. Sharma, uh, Madam has rightly pointed out that there is a mention of the grandfather, which perhaps is not there in the written statement. We have verified from the written statement. That part will go. But in the decision-making process, it will not make a difference. But nonetheless, it's pointed out there should not be any factual incorrectness in the judgment. That will be corrected. Date of birth, this was the date of leaving the school. So that will be corrected. But in the writ petition also, the year has not been correctly written. It's written 74. But we'll have it correctly written as 31/12/1973, year of living. That's not the date of birth. And registration certificate, since it is there with them, they can utilize while applying under the CA. And the last will not allow. Last is a document has been procured after the that will not change the judgment. Okay.
Of late.
We will dispose this of. Paragraph C, written statement of page 87.
Written statement page 87. Only-
Of the reviewed.
Oh, mm.
Last.
87A.
87, last item, real fact. Real fact.
Mm-mm. Okay, so the father, okay, opposite party came to Assam and settled at Dhaka, but so grandfather was not there. Can you more put little?
You have to put paragraph 8.
8.
You have to find
No, no. 8, okay.
it.
Okay. His father and grandfather came from. Okay. Mm. I was silent, no? Okay, no? Due diligence taken was there.
It is not legal. We'll dispose it. This court fully endorses the principle that while eligibility criteria are to be construed strictly, the procedural part are to be construed liberally so that there can be maximum achievement of the objective. Present rejection being only on the ground of limitation, this court is of the opinion that interest of justice would be served if the impugned communication dated so and so is set aside and interfered with and the matter be considered on merits. The impugned communication is accordingly interfered with and the matter has been remanded back within 4 months.
Wait, please, Your Lordship. Lordship, item number 54 with the consent of Mr. Sharma, my lord, I may be allowed to withdraw this petition, my lord,
54.
on instruction, my lord.
Settled,
My lord,
settled,
my lord, there's some encroacher, they are going to settle with encroacher, my lord.
settled with the encroacher.
My lord. Locality, my lord, they're disturbing us, my
Okay.
lord, so.
Sri N. Bora, learned counsel for the petitioner, has submitted that he has instructions not to press the writ petition. Also heard Sri G. Bokolia, learned state counsel, and Sri P. Sharma, learned standing counsel, AFDC. Full stop. Writ petition is accordingly dismissed on withdrawal. Interim order?
No, nothing.
Yes.
Lordship, item 55, we are intended to withdraw our wakalatnama.
What is your name, madam?
P. Devi.
Okay, let the matter be called upon. Has any new counsel taken over? Has any new counsel filed wakalatnama?
No.
Let it reach, then we'll remember you that you have, okay.
My lord,
Yes.
item 56, this is also connected, my lord. So in this case, I am supposed to file one IA, my lord.
IA for
IA for, my lord, impleading the president of the managing marketing committee.
impleading.
Impleading, my lord. But that has not been done, my lord, because IA is ready, but the party did not come to sign that.
Then we'll adjourn both the matters and we'll
Tag-
also record her
Yes, it is
submission.
tagged with, my lord.
Okay. Ms. P. Devi, learned counsel has submitted that they have withdrawn from the case. No, so far as WPC 55-1151-2025 is concerned, huh? That's what. In WPC 407 of 2026, Sri A. Ali,
My,
learned counsel has submitted that an impleadment application is ready to be
Right.
filed and he prays for a little accommodation. Foot stop
Right.
para. Matters are accordingly adjourned by 1 week.
my,
Can you file within a
My-
week, by a week? To enable filing of impleadment application.
my,
List on, we have on 7th of September.
my.
7, 9, both the, type order. 55, 56, yes.
Obliged.
May I please? Please, I beg to mention item number 57 of the supplementary list.
Hmm.
Lord, with the consent of the other side, I'm praying for some time to file an additional affidavit, my lord. They had filed a reply to our affidavit in opposition. Now, certain facts needs to be brought on record, my lord. Some,
Where is the scope to file response to rejoinder?
my lord, not a rejoinder, my lord, by some documents needs to be brought on record, my lord.
These are not, proceedings have to come to an end at some point of time.
My lord, there are certain documents which were left behind, but which we got to know after they filed a reply, my lord. So just a
What was the name?
N Patiri, my lord.
For
For the
ATEF,
respondent, my lord.
ATEF,
ATEPFO.
Okay, Sri N. Patiri, learned counsel appearing for the respondent has submitted that has prayed for a liberty to bring certain documents on record by way of an affidavit.
Affidavit.
Full stop. He has, however, informed that pleadings have already been exchanged. Para. Considering the above, the liberty is granted and such affidavit be filed within a period of 2 weeks.
My lord.
List on 9th of September,
My lord.
9/9. Yes.
Deeply obliged.
May I please, Lordship? Lordship, I beg to mention item number 29 to be.
Mr. Patiri, what, there's an office note. Why is it office note?
Lord,
Office note for what?
Lord, I'm not aware, my lord. They were supposed, they were filed a
The
reply.
office note you should not mention, you should check the office note. Are there any other respondents, Mr. Sharma?
No, ma'am.
Pleadings are over.
Ma'am.
Office note to count, yes.
Well, when they filed a reply, some annexures were left behind, so they, I think they have refiled it.
Petitioners have filed press affidavit against the affidavit wherein the petitioner missed how to tag filing affidavit. Now the okay, no problem.
Great.
Yes.
Lordship, I beg to mention item number 29 to be taken up after 1 week as my senior is out of station. Lordship.
29.
Yes, Lordship.
29.
Who is your senior?
SD protester.
For the respondent? Inform the other side.
Yes, Lordship.
Okay. On a request made on behalf of Sri SD Purkasta, learned counsel for the respondent number 7, Matter is adjourned by 2 weeks,
1 week.
1 week. Full stop. List on 7th of September.
Lordship, there's an interim order.
7/9. Interim order passed earlier stands extended till the next date of listing.
Obliged. May please, your lordship, my lord, may be permitted to mention item numbers 11 and 12,
Yes.
my lord.
Yes,
May I pray these be taken up on 3rd of September as leading counsel, Mr. K. N. Chaudhary is out of station, my lord.
okay. On a request made on behalf of Sri K. N. Chaudhary, learned senior counsel for the petitioner, matter is adjourned to be listed on 3rd, 3/9,
Obliged, my lord.
separate orders, huh? 11 and 12.
May please, your lordship. Lordship, in respect of-
You are there, madam?
I'm in 11.
CGC. Okay. Now here, M. Kotoki, learned CGC is present. And 12, who's there? 12, okay. G. Bukulian. Will that be? Take us. Yes,
Lordship, in respect of-
12, you are CGC.
Yes,
Since when?
recently, my lord.
Recently. We don't know about it.
First of July.
So that, but does the bar knows about it?
See?
Bar members knows about it. Have you given some?
Okay, Sudhir has given me, my lord.
No, have you given them something?
Yes, my lord.
No demands.
No.
What is the bar doing? New assignment.
It is,
How can he take over new assignment?
Due to executive member to the party is here, my lord.
Okay, that is a different party.
Yes, my lord.
So you should learn from that party. So another is due. Okay. That are each does. Okay. Yes, next.
Lordship, in respect of item number 28, Lordship,
2/8.
yesterday we had filed an adjournment slip. Lordship, the matter may come up after 2 weeks.
I'll pay for the other side, Your Lordship.
We have
Why
consent
do you
of all
need
the
time?
part- Lordship, the affidavit in reply is almost finalized, Lordship.
You will file affidavit reply.
Lordship,
Okay.
Lordship.
Sri your Sharma B. Sharma.
Be sure, Lordship.
Sri B. Sharma, learned counsel appearing for the petitioner, has submitted that the rejoinder affidavit is ready and will be filed shortly. Full stop. He accordingly pays for and is granted a week's time,
2 weeks time, Lordship.
granted 2 weeks time. Full stop. List on 11th, not 11th, 9th of September. Is it okay?
Lordship.
9th of September. 9/9.
Possible record.
Sri
Okay.
A. Sharma,
For all India.
learned counsel for the All India is present.
Okay.
A. Sharma for the All India and Sri H.K. Sharma for Arts 3 are present. Item 1. Yes, what is this?
May I please, your lordship? Your lordship praying for withdrawal of the petition.
It
from
has been
the-
complied with?
Yes, your lordship.
Complied with?
They are complied with the respondents.
Okay, what is your name?
Your lordship, Ayas Tofik, A Tofik.
A. Tawfiq.
Yes, your lordship.
Heard Sri A. Tawfiq, learned counsel for the petitioner, who by means of this application had complained regarding the willful and deliberate disobedience of an order dated 14/8/2026 passed in WPC 4369 of 2026. Full stop. Para. The learned counsel has however submitted that after filing of this case, the order in question has been complied with, and therefore he would not like to press this application. Para. The petition is accordingly dismissed as not pressed.
God bless you.
No, don't say. This petition is accordingly closed. Mr. Doctor, what is this?
Lordship, suspension of fair price of license, Lordship. Last occasion, Lordship speaks for instruction. Lordship.
Instructions, yes.
Yes, ma'am, I have received instruction, my lord. So cause notice has been issued, my lord.
Show cause is issued, but suspension was done when?
24/12/2025.
24/12/2025.
Yes, my lord.
Can you can you go ahead with the suspension? Continue the suspension?
Yes, my lord. If my lord, so cause notice was not issued within 90 days.
Let us see the provision.
Yes, madam.
Yes, 1982 orders from the
Public distribution article.
public distribution.
15 my lord.
Public print করে থৈছিল না? এইখন আছে। এইখন না। তার তলত দেখোন। পড়ো। এইখন। এইখন নেকি? Yes, please read it for us.
Yes, my lord. 15 my lord. no order of cancellation shall be made under this clause unless the licensee has been given reasonable opportunity or stating his case against the proposed cancellation but during the pendency or in contemplation of the proceeding of the cancellation of the license can be suspended for a period not exceeding 90 days without giving any opportunity to the licensee of stating his case. In that case,
So
already-
for the suspension, there is no requirement to give an opportunity.
Yes, my lord.
But that suspension can be for 90 days.
Only for 90 days, my lord, if no proceeding has not been initiated.
Is it
during that 90 days, my lord.
Don't have the Asana copy to put. Can you, do you have a copy?
Yes.
What is the meaning of this, Mr. Doctor?
Lordship.
15 to my lord.
আসিল আমার ওগুলো কোড করে এখন No order of cancellation shall be made under this clause unless the given but during the pendency of the or in contemplation of the proceeding of cancellation, a license can be suspended for a period not exceeding 90 days without giving an opportunity.
Without,
Yes.
if my lord, within 90 days, my lord, so goes given, my lord, then my lord proceeding can go on, my lord.
Is that the meaning?
Yes, my lord.
Yes, what do you say?
Lordship, I have given my reply on.
No, on this point of,
All this,
on this interpretation.
in fact, my lord, they have in the repetition, my lord, they have not mentioned about the issuing of so called notice and giving
Lordship,
reply,
in
my lord.
para 8, I have given as a representation, Lordship, against
Yeah,
my
given a
reply.
representation to withdraw the suspension, but
So called notice has been replied.
my lord, that has
Yes,
not been,
Lordship,
have not
as a
instructed, my lord.
representation, reply as a representation, Lordship.
No, my lord.
Mr. Bora, what is the interpretation of 15(2)?
Yes, Lordship.
Mr. Chetia is trying to give another interpretation.
No, Lordship, as per my understanding, Lordship, the entire proceeding has to be completed within 90 days.
Please read it. Take the copy from Mr. Chetia. We have got your copy.
No order of cancellation shall be made under this clause unless the licensee has been given reasonable opportunity or stating his case against the proposed cancellation. But during the pendency or in the contemplation of proceedings of cancellation of the license can be suspended for a period not exceeding 90 days without giving any opportunity to the licensee of stating his case. Now it means first there may be a show cause, but that show cause has to be in contemplation of cancellation.
Yes, ma'am. That is the so cause, ma'am.
He says the chocos has already been issued. So this not exceeding 90 days is only for the aspect of not giving opportunity before suspension.
Yes, ma'am.
That is his contention.
Yes, but
So we'll consider this.
in this case, Lordship, in
Lordship,
case of
my lord, we will-
cancellation of a license, the entire proceedings has to be completed within 90 days. Lordship.
No, my lord, that is.
Where is it given?
Lordship, once again, I'll read.
No, it's not like that.
No order of cancellation shall be made under this clause unless the licensee has been given reasonable opportunity
We'll have this on Thursday next,
yes, Lordship.
Thursday, on this
Yes, sir.
point, okay?
Maybe there will be some judgments also.
Okay.
Interpreting this point. Yes.
Heard Sri BP Bora, learned counsel for the petitioner. Also heard Sri M. Chetia, learned learned state counsel, who has placed before this court written instructions dated 24/8/2026. Full stop. There is, however, a dispute, variance in the interpretation of section of clause 15(2) of the Assam Public Distribution of Articles Order 1982. Para list for motion on Thursday.
Yes.
We'll give some
Deeply
time.
obliged.
Thursday, this court may not be there, whoever is there. You try to sort it out, okay? এটা আমার কপি, এটা প্রিন্টারটা উঠাইলো পারে এটা।
Lordship, since your lordship has heard this, lordship, if lordship gives the appropriate date so that we can.
No, 2 weeks, this court is not there. Unnecessary should not halt. You try it before, if it is come before us, ultimately we'll be very happy to deal with it.
Deeply obliged.
Mr. Bora, you take this back, and Mr. Chettiar.
Sorry, lordship, it was marked.
Doesn't matter. And there are printing errors also.
Yes.
Printing
lordship,
errors are there. Off is there, by has come.
By has there. Yes.
For it has become or.
Or, yes. Deeply,
You try to get it from the local X.
yes.
It is there. Yes, what is this?
May I please, Your Lordship?
Yes.
My lords, the present writ petition is filed challenging the circular dated 25th March 2026. My lords, in this circular, whereby a 23-year-old long-standing concession regime on freight rate for transportation of salt was withdrawn without following the due procedure and mandatory approval of the Parliament, and is in violation of Article 14. And my lords, no reasonable.
You are challenging a circular,
Railway Board circular.
25/3/26.
Yes, my lords.
What is that circular about?
My lords, basically, my lords, if my lords, I may give a brief overview of what has happened with the.
No, we can issue notice at this stage.
My lords, if I may for interim stay, my lords, on this
Interim
circular.
notification will
My
not
lord,
stay.
My lords,
Notification will not stay.
my lords, if I may say so, my lords, these are very financial.
That is the exact reason we are not staying.
My lord, the essential commodity salt, my lord.
We'll have a short date. Madam, you after your instructions. There is urgency expressed, okay? You are Dirathi.
Dirathi.
Heard Sri Dirathi, learned counsel for the petitioner who has put to challenge a railway board rates circular number 5 of 2026.
Yes, my lord.
Within bracket corrigendum number 63, bracket close dated 25/3/2026. Full stop. By the said circular, comma, a graded freight FREIGST concession regime for transportation of salt for human consumption has been repealed. Full stop. Para. Let notice be issued, returnable on. Are we giving a short date, madam? Today is 28th. We'll have it on 18th. You come back, okay? 18th of September.
My lords, if any date apart from 18th, my lords.
Then we can have it on 21st is a holiday, cannot. Maybe 23rd?
Yes, madam.
23rd of.
Great.
Okay. So you for all, madam?
Yes, all from all.
Again, CGC accepts for all the respondents. Para. Let extra copies, huh? Since our urgency has been expressed, comma, the learned CGC is directed to obtain the instructions by the need.
My lords, my name can be mentioned in the order sheet, my lords. It is not
Yes, sir.
It is not
The-
reflecting, my lord, Divyam Rathi.
Cause list.
In the cause list as well, my lords.
In the cause list, you are not Dirathi.
My lords, I am D Rathi. There are two D Rathi, Divyan Rathi and Divyam Rathi, my lords. I am Divyam Rathi.
Oh. Okay. The name of the petitioner, give your full name, right full name, huh? Be reflected in the cause list.
Grateful, my lords.
Yes.
Your Lordship. My lord, this matter pertains to the contractual dues of the petitioner from Lordship. Regarding the non-payment, Lordship, of outstanding bills amounting to rupees 13,50,600 in connection to the execution of public works, Lordship, the acknowledgement of liability by the department is at page 14, Lordship.
1/4.
Yes, Your Lord. Serial 1.
One four.
Yes, Your Lord.
Yes, what do you say, madam? Take it. Okay. Item number?
4.
You are Y. Borbhuya.
Yes, Your Lordship.
Heard Sri Y. Borbhuya, learned counsel for the petitioner who by means of this application has prayed for a direction for release of contractual dues, full stop. The learned counsel has relied upon a communication dated what February? 22, communication of February 2024 issued by the District Commissioner Darang to the CEO Darang Jila Parishad for taking steps. No, forwarding the bills. But is this a acknowledgement?
Yes, your lordship.
Where is the acknowledgement?
This is a forwarding letter, lordship.
Forwarding is not an acknowledgement.
Lordship, they have
There's a
forwarded.
difference between forwarding something and acknowledging
Lordship,
something.
Serial number 1, lordship. Bill
Yes.
submitted by the Masum Enterprise for the
This is
family.
your bill. Where is the acknowledgement that yes?
Next page is also the forwarding of the same bills, your lordship, for providing the basic minimum facilities that was providing for the shifted families from Garukati area to Arimari and Shampur.
But
Two
these are
villages.
not acknowledgement per se.
But there is a
Difficult,
letter.
Kolo. Hmm? Which organization? Custodian. Forwarding wills, full stop. Miss P. Thapa, learned counsel appearing on behalf of Sri S. Datta, standing counsel PNRD has however submitted that the said that whether the said communication can be regarded as an acknowledgement would itself be an issue. Full stop para. Be that as it may, let notice be issued, returnable on when?
23rd, lordship.
23rd of September.
Similar is
23rd of September. Ms. Thapa, the learned counsel, accepts notice on behalf of Restaurant 1, 3, 4, and 5. Mr. Bokolial for 2. And 6 by Speed Post PTD. 2 Baki, 2 dear episode. Extra copies. 6 Speed Post PTD.
hello, lordship.
Steps within 2 working days. Item 5.
May it please your lordship. In this matter, this is against the notice of termination of a contract, my lord.
Termination of contract.
Termination of
What about arbitration?
arbitration clause is there, my lord, clause 27.
Then
However, my lord, here, my lord, since the fairness has not been followed, my lord, the fair procedure
this
has not
ground
been
you cannot raise in the arbitration.
followed. My lord, we can, but
On this ground, it'll go.
ultimately,
And what relief will you get in a writ proceeding?
my lord, as of now, what we have learned, my lord, is that
When was it cancelled?
but it has not been cancelled. The
Then?
notice has been issued, my lord. And they say that after within 30 days, if I don't reply, which I have, they would terminate the contract. They have not terminated the contract, but my instruction, my lord, as of now, after filing the writ petition, they have floated a new tender. But effectively, my lord, that would imply that my
Have you put this on a record?
no, my lord. This we
You
learned.
file an IA?
My lord, later on.
We can have this on Monday if you can file it by tomorrow.
Right.
Or if you want Tuesday also, we can have it.
Monday, my lord.
Monday?
Who is it?
The IA will come.
Tuesday, my lord.
Tuesday.
Tuesday.
Okay.
Mm,
Heard
signature.
3 PD Nair, Learned Senior Counsel assisted by Ms. N. Upadhyay for the petition. First up, at the outset, the Learned Senior Counsel has submitted that there are certain developments subsequent to the filing of the writ petition, which is required to be brought on record, as the same would have a material bearing in the decision-making process. What's the para? Matter is accordingly adjourned to enable the petitioner to take appropriate steps. List as urgency has been expressed. List on Tuesday, along with any application that may be filed in the meantime.
Deeply obliged.
Tuesday is a holiday.
Oh, Wednesday, my lord.
Wednesday.
Wednesday.
Second.
Deeply obliged.
May it please your lordship. Regarding detailed outlet, your lordship, in draw of lot, my lord, I was selected, my lord. And then I was offered all land document, everything, my lord. Now, my lord, I have also applied for partition of my land, my lord. And after partition, my lord, on the wrong calculation, they have, my lord, cancel my candidature, my lord. The annexure 13, your lordship, kindly see that in the total, my lord, in this old DAG, that was, my lord, I have submit my document in the old DAG, my lord, but in the meantime, my lord, I file application for mutation also. So it is separated. Now they are taking on the residual part, not in the part which was allotted to me, my lord. So land which was offered by me, it is intact in my name, my lord. That is enough.
Which communication? The communication dated?
That is, my lord, 11 August 2026, my lord.
Recent communication by which your candidature has been rejected.
My lord.
Now, any further development, Mr.
No,
Barwa?
it is not yet, my lord. Redo has not been done.
We are not proposing to issue the LOI because of two critical irregularities. Number one, the land offered includes the land by a brother-in-law who does not fall within the definition of family. Secondly, my lord, the land offered at the last date of application was less than what was the land.
That is what Mr. Mahanta is saying.
Subsequently, the land was brought in from another DAG, which was after the date of application in 2025. That cannot be considered, my lord. It is a change in the material circumstances after the date of application. And that is a dispute as to how much land. Even now, the land is inadequate. As per our title search report, I only pray for 2 weeks time to file my complete affidavit.
Then we'll go for a disposal early. We don't want to.
Disposal.
If he has a case, he has a case. Otherwise, you go ahead.
From their statement, it is clear, my lord. They have
Okay.
not.
Okay.
So
Heard Sri T.J. Mahanta, Learned Senior Counsel, assisted by your name?
MR Islam.
M.R. Islam for the petitioner. Full stop. The grievance of the petitioner. As per the case, as per the facts projected, pursuant to an advertisement for allotment of retail petrol pump, retail outlet within
Retail
bracket petrol
outlet,
pump, the petitioner claimed to have been categorized in group 1 and was also successful in the draw of lot.
Drop lot.
Full stop. It is, however, the case of the petitioner that her candidature, her candidature has been wrongly rejected by misinterpreting and miscalculating the aspect of the requirement of land. Full stop. Para. Sri N. Barwa, Learned Counsel appearing for the IOC. IOC has, however, submitted that the rejection is on substantial grounds and has been done by taking into consideration all the relevant factors. For the para, be that as it may, let notice be issued, returnable on 16th of September. Can you do it before 16th?
Yes.
16th of September 2026. Union of India, anybody is there? The Union of Ms. Ega and let it say for 1, 2, 3, 4 by N. Barua. Extra copies. Sri Mohanta, the Learned Senior Counsel, prays for an interim order. Footstep. Sri Barua, the Learned Counsel for the IOC has, however, submitted that no steps have been taken for fresh allotment. Footstep.
Fresh reader.
Huh?
Fresh reader.
No steps taken for a new draw of lots. For a fresh draw of lots, para.
In respect of tail number
By balancing the equities, it is provided that till the next date, fixed, status quo as on today,
My
be maintained.
Deeply.
Full stop. Since the matter pertains to allotment of a petrol pump, which is directly connected with public interest, this court would make an endeavor to have an expeditious disposal of the writ petition
Deeply.
after filing of the pleadings. Yes, Mr. Patra.
The petitioners have purchased 2 properties, my lord. Under the sales certificate issued by Punjab National Bank, respond number 5.
You purchased 2 properties.
Petitioner number 1, my lord. The sales certificate is at page 25, my lord, annexure 1.
This was the landed property of 25 bighas and odd. In this,
Okay.
and the second sale certificate was with regard to the plant and machinery, madam,
Hmm.
which is at page
Two,
28.
two sale deeds.
Two sale certificates, my lord, issued by
of-
Punjab National Bank
Oh, from in an auction?
in an e-auction, my lord.
Okay.
Yes. My lord, the petitioner number 1 and 2 are, my lord, sister concern, my lord. The petitioner number 1, my lord, sold a portion of 1 bigha and odd land to petitioner number 2 to set up a beverage plant. Pursuant to taking over, it was found that the connection, electric connection, which was to the premises, was not inadequate. It was not adequate. So, my lord, an application was made for load sanction of 540 watts with the APDCL.
Yes.
My lord will kindly see the sale certificate once, my lord, annexure 1.
What is your difficulty, Mr. Bhatra?
My lord, the load sanction which we have applied for was rejected, my lord, on the ground that the erstwhile owner had a due of 4 crores and odd amount. That was with regard to some theft of electricity done in the premises.
But there is a provision in the Electricity Act.
Yes.
You buy it as where is as its basis.
But my lord, with regard to theft, my lord, when it is a penalty, some compensation is imposed. Well, had it been a statutory
No,
responsibility.
theft by whom? Theft by the earlier owner.
Yes, my lord.
So those are dues. When you buy it, you have to make a due diligence exercise. We have dealt with these matters, not exactly of theft,
My
but
lord.
of dues.
My lord.
If you want to make, if you want to make a distinction between a normal due
Exactly.
and theft, that's a different matter.
Exactly.
But
That is my case, my lord.
yes, Mr. Pathak, one case we have dealt.
My lord, in fact, otherwise the issue has been settled by the Supreme Court. Just one technical aspect which I wanted to point out before proceeding on merits. Your lordship has the document at page number 46. That is the rejection order. It's dated 22/1/2026.
Applicable 160.
No.
20 page 20.
Page number 46.
46.
Yes, my learned friend will correct me if I'm wrong. That is the rejection order of 22/1/2026.
Correct.
That has not been challenged, my lord.
Oh. That is not challenged.
No, my lord.
46.
Page number 46.
That
Here's your
Mr. Bhatra can do it. That's not a problem. Mr. Bhatra, is it left out or what?
Maybe, my lord. Maybe in
Page number 21.
Mr. Bhatra, put that to challenge. You will not say anything now. Okay.
And it's on the merits.
No, we'll not say anything. Let him amend the petition. It will not be fair otherwise. You proceed then tomorrow. It's good that you have pointed out the first. At the outset, Sri R.K. Bhatra, learned counsel for the petitioner, has submitted that due to inadvertence, the order of rejection dated 22/1/2026 has not been put to specific challenge, has not been specifically challenged. I also heard Sri K.P. Pathak, learned standing counsel APDCL, Mr. Datta for, and Sri S. Datta, learned for the Punjab National Bank. Both the learned counsel for the respondents have not raised any serious objection to the permission granted by Sri Bhatra to amend their petition. Sri Bhatra, the learned counsel, is accordingly granted a week's time to amend the petition by putting the rejection order, by making a specific challenge to the rejection order dated 22/1/2026.
Obliged.
Please, immediately after filing of such amended petition.
Obliged.
May I please, Your Lordship?
Mr. Saikia, what is this?
This is regarding on the settlement of market.
Hmm.
And that I have participated along with 3 other tenderers for my lord, Anand Bazar Weekly Market under BTC, my lord.
Hmm.
My lord, the comparative statement is that, my lord, the page, my lord, the 12.
Page 12.
Page 12, my lord.
Yes, what is there?
There, my lord.
Not
I am-
12. 12
I am
is
the
your,
highest bidder.
12 is your affidavit.
Pe-
12 is your affidavit.
Annexer 12, my lord, page 36.
Page 36.
Annexer 12. Sorry, boss.
The comparative statement.
Yes, Lord. My lord, I am the highest bidder. I have offered my lord 11 lakhs 10,000. And the second highest bidder, he has offered my lord 7 lakhs 10,000. My prayer, my lord, the bid was
What is your
rejected.
name?
My name is my lord Joy Saran Narjari,
Joy Sharon is the petitioner.
petitioner, my lord.
Private respondent is also there.
Yes, my lord, that is Bhaskar Musahari.
Now, his our respond number
Respondent number 5, my lord.
R5.
R5.
Yours is 11 lakh 10,000.
10,000, my lord.
His is 7 lakh
7
10,000.
lakhs 10,000, my lord.
So,
My lord,
8, 9, 10, 11, 4 lakh more.
4 lakhs, difference of 4 lakhs.
Okay.
My lord, my prayer, this tender was rejected on this ground, my lord, that is on the remark.
Yes.
2 envelopes enclosed, one in name of Poop Thorbury bi-weekly market and one Ananda Bazar bi-weekly market. That is the, my lord, while giving the, my lord, envelope, my lord, there is some inadvertent mistake. But my lord, inside, my lord, all tender paper, my whole tender paper, it belongs to the Anand Bazar weekly market. They have considered it for this market. And they have rejected in this ground, my lord. Because inside the all documents which I have, they have, including the form and all, my lord, this is regarding Ananda Bazar, my lord. And there is a, my lord, difference of 4 lakhs, my lord. It's a huge.
Yes, what do you say, Mr. Atre?
Prima facie, there seems to be the technical error on which ground it was rejected. In the public.
No, we are interested to know what was there inside the envelope.
Yes.
You take instructions.
I'll take it.
But have you given the order?
Yes, Lordship. Of 5th August. The order
5th August already there.
Operating. I'll get instructions on a short date.
Will you take dusty upon the private respondent?
Lordship,
Okay.
Lordship.
Without
And my
hearing
lord,
him, he
moreover,
has.
this private respondent, my lord, his non-encumbrance certificate was also not, is also not there.
And that is, those are okay, but since he has taken over,
Lordship.
we cannot pass an interim order. At the same time, how much is the tenure?
My lord, 1 year. My lord.
1 year. You take dusty also upon the respond number 4, 5, we'll consider. Third, 3, use this Saikia learned counsel for the petitioner who is aggrieved by the outcome of a tender process for settlement of the Ananda Bazar weekly market. Full stop. As per the facts projected, comma, the value offered by the petitioner was the highest, whereas the market has been allotted to the respondent number 5, whose value was less is less by 4 lakhs.
4 lakhs.
4 lakhs. Full stop. The learned counsel has submitted that on a very trivial ground, the bid of the petitioner has not been considered, namely, considered. Full stop. He has submitted that while 2 envelopes were required to be, while the papers were required to be submitted in 2 envelopes, comma, on 1 envelope, comma, name of another market was inadvertently written. Full stop. He has, however, emphatically submitted that the documents were pertaining to the bazaar in question, namely Ananda Bazar.
Lords.
Market in question, namely Ananda Bazar. Let notice be issued. Returnable on 18th September. Mr. Atre, for whom? BTC?
Yes, Lordship.
You are standing counsel BTC?
Yes.
Sri Atre, learned standing counsel BTC, accepts notice on behalf of respondent 1, 2, 3, and 4.
No, Lordship. 1, 2, and 4.
1, 2, and 4. Okay, 3 is district commissioner.
Yes.
Yes, Mr. Chetia, 1, 2, and 4. 3, Mr. Chetia, state council. Extra copies. 5 by speed post PTD. Dusty also.
Yes.
Okay, you get it through the registry. You know the process, and you have to file an affidavit before the next date regarding Dusty. GA sum be reflected in the court list.
Let it come on, my lord, 18th, my lord.
18th, yes, sir. You file a affidavit before 18th regarding the state. Item 9.
May I please, your lordship? Lordship, in this petition, lordship, petitioner has challenged the arbitrary and illegal action of the respondent authorities in favoring the bid of respondent number 6. Lordship, what happened, lordship? The bid which was called on and the respondent and the documents which the respondent number 6 has given.
Bid for what? Grant of IMFL?
IMFL, lordship. IMFL, that page 18 is the bid reference number and page 19 is the bid opening date and the closing date.
So what has happened?
Lordship, in this bid, lordship, respondent number 6 has submitted the documents, that is the Bakizai clearance certificate, which is one of the essential requirement. He has submitted in the year for the year 2024. Although the bid was also called in the year, but his clearance was still 24/1/24. Bakizai clearance was valid, and moreover, the land clearance certificate, that is the land revenue, he has submitted of 22/23.
Not current.
Not current.
So even Bakija and land, as on date, you are not very sure whether he is qualified. That is your case.
Yes, yes.
You otherwise your papers are in order.
My papers are order, lordship. My papers are in order. But what happened, lordship? Lordship, in this one, earlier also petitioner had filed one case, lordship. WPC, lordship. That is the page 59.
6, 7 to 8.
Yes, lordship.
That we have withdrawn.
That has been withdrawn, lordship. That has been withdrawn, and there it has been given the liberty.
Yes, Mr. Sharma.
We'll give instructions on this matter, let notice be issued.
What is the stage?
That's,
Stage, Mr. Das.
Lordship, till date, no issue. Means license has not been issued, lordship. It is still pending.
Heard Sri R.M. Das, Learned Counsel, for the petitioner, who has put to challenge the action of the respondent authorities in regarding the bid of the respondent 6 to be valid, full stop. It is the projected case that the petitioner and the respondent 6, along with others, had bidded for grant of an IMFL retail off license for the Dhukuakhana town. Full stop. It is contended by the petitioner that the Bakizai certificate and land documents are not up to date.
Lordship.
And yet, the bid of the said respondent number 6 has been considered. Full stop. The petitioner, the Learned Counsel has on the other, the Learned Counsel has contended that on the other hand, the documents of the petitioner are in order, are up to date and in order. Let notice be issued, returnable on 23rd of September 2026. S. Sharma.
yes, Your Lordship.
S. Sharma, Learned Counsel representing the Excise Department, accept notice on behalf of 1, 2, 4, 5.
5 minutes.
5 Commission, District Commission, District Commission. No, 5 also, I think. 1, 2, and 4.
1, 2, and 4, Your Lordship.
4. And Mr. M. Chetia for 3 and 5. Extra copies, 6 and 7 by speed post to AD.
Your Lordship, as per the stage, I have just received instructions. The license has been issued, Your Lordship.
Is it? Sri R.M. Das, Learned Counsel, for the petitioner praised for an interim order. Full stop. Sri Sharma, the Learned Counsel for the department, has however informed that license has already been issued. Full stop. In view of the above, comma, the blanket interim order is declined to be passed, comma, status quo as in today is directed to be maintained. Name of GAB reflected in the cause list. You should have come early, Mr. Das.
Lordship.
GS.
May I please your lordship?
Yes, what is it?
Lordship, in this case, what happened? The Tea Board India Zonal Office Gauhati had invited a tender for repair and renovation at their office complex on 18 February 2026, for which your lordship, the petitioner has applied for. He had filed a tender, your lordship, and the contractual work
The
was
work
given
was
to
for renovation of?
renovation of their office complex.
Okay.
Then your lordship, he was given the work, and work order was published on 9th March 2026. The work was to be completed by 13/5/2026, your lordship, and then the petitioner started his work. Once he started his work, he was stopped by the respondents, your lordship, and then another advertisement for the fresh advertisement for the same piece of work was published on 7/8/2026. For that, he had made a representation. The representation was made on 6th August 2026, and immediately on the next day, a fresh tender was published by the respondent. I'm challenging that new advertisement, your
But
lordship.
you did
because-
not complete the work within time. It was two months time was granted.
No, your lordship, as soon as I started the work, I was stopped. I was not allowed. I approach each and every person.
You had started.
Yes, your
You were
lordship.
not allowed to proceed with the work.
Yes, your lordship.
Some facts have not been brought to light. In fact, what she's submitting about is the third tender process. Tender was issued in the month of January, where my friend had participated. She's put at a rate, and thereafter work was allotted. Then she expressed her inability to do the work. So January tender was again cancelled. Another tender was issued. Now, in January, my friend quoted a rate of 14.99 lakhs. In the tender issued in February, she has quoted 37.45 lakhs. Now, that was a big difference. Hence, Lordship, this tender was cancelled and it was uploaded in the GEM portal in the month of March. And it's a new fresh process. So there was a huge difference. It was more than double. Therefore, it was cancelled and it was uploaded in the GEM, Lordship. So therefore, perhaps the contentions raised.
Third in the GEM when?
Third, Lordship, is the recent one which she is putting on the challenge.
GEM, and this is under GEM.
This is under the e-procurement system.
That is under GEM. What date?
That is 7th August.
7th August. You, madam, you participate in this.
Lordship,
let her participate in this.
Participate.
And in fact, I am told that.
And all procurements are mandatorily required to be done under GEM.
Lordship, why my tender was cancelled? It was not. The reason was not given to me. Lordship, I may be given some time to clear out the things I heard now, your lordship, from my client, your lordship.
No, you participate. We will not stop this.
Or
And
7 days time, your lordship, so that I can clarify certain things, your lordship.
it's up to you. You move after 7 days.
Give me 7 days time so that I can clarify the things, your lordship.
Heard.
Speed us, your lordship.
Speed us, learned counsel for the petitioner, whose grievance is with regard to a renovation work of the office of the Tea Board. Full stop. Para. Sri R.K.D. Chaudhary, learned Deputy SGI, and Senior Counsel assisted by Ms. L. Devi, has however submitted that facts as projected in the writ petition are not correct, and the present process present process dated 7/8/2026 is initiated through e-portal, which is the requirement. Para. At this stage, Ms. Das, the learned counsel for the petitioner, prays for some time to obtain instructions.
Yes, yes,
Para.
lordship.
Matter accordingly stands adjourned to be listed on Friday next.
Yes, yes, lordship.
Date. On this will be on Friday is a holiday on 7th.
Yes, your lordship.
7/9.
Leave your lordship, your lordship.
Item 14.
Method that pertains to
Item number?
13, contractor bill, my lord.
Hmm.
Non-payment of contractor bill, my lord. Kindly see page 26, my lord, liability statement.
Page
26, my lord. Petitioner yet to receive 10,76,166, my lord.
What is this?
My lord, this is the my
No,
lord,
no,
liability
madam.
statement, my lord.
This statement is there, but work order is of 2012-13 also.
But this is also recommended by the additional chief engineer.
Chief engineer.
You take instructions on this. Third, Sri K.R. Padgiri, learned counsel for the petitioner, who by means of this application is praying for a direction for release of contractual dues, full stop. He has submitted that in the liability statement, comma, there is a recommendation by the additional chief engineer. Full stop, para, that notice be issued, returnable on 18th of September 2026. Miss R. Das, R. Deca, learned standing counsel, Water Resource Department, accept notice on
7, 10, 9.
1, 6, 7, 8, and 9. Finance, A. Chaliha, 2. Then Union of India, Madam A. Gayan, 3. Brahmatra Board, anyone? Brahmatra Board also. Then 4 also, huh? 3 and 4. AG, R.K. Talukdar. Your name, give your name on behalf of R.K. Talukdar, Accountant General. And rest, who is it also? Water Resource. Town protection, this is Water Resource only you have taken.
Water.
7 also.
Yes.
Okay, extra copies.
My lord.
Oblige.
Okay.
Yes, Madam Chaudhary.
Yeah, Lordship, page 14 is the liability statement.
14.
Lordship. Part payment already made.
Okay. Same order, huh? K. Chaudhary hobo. Aru, date question ne kago kiba date asile niki. Recommended by the recommended will have containing the signature of the chief engineer. Okay. Then notice same. What about 1? 1 and 2 E guy and 1 and 2 CGC, huh? And Ardeka 3, 4, and 5. 6 also. 6, 7, and all these other extra copies.
15 similar matter, Lordship.
15, Lordship, there is no, Lordship, work order is of 2012, your Lordship.
Where is the which date, Madam Chaudhary?
Lordship, page 16 is the RTI reply and 17 is
17 is not of the chief engineer. It is different from 16.
Lordship, this is executive engineer, Lordship.
I'll not do. This will not do. This will not do. This is this, and this bills are of 2012, 16.
Lordship, part payment already made, Lordship. Only balance
Taken,
amount.
but how do you entertain a writ petition?
Lordship, there's a liability RTI reply is issued on 24.
You have to go to the civil court. Unless there is a liability by the chief engineer. This we cannot entertain. Third, Ms. K. Chaudhary, learned counsel for the petitioner, who by means of this application has prayed for a direction for release of contractual dues. Full stop. The learned counsel has, for the petitioner, has relied upon a document obtained under the RTI, which include a liability statement. Full stop. Para. Both Ms. R. Deca, learned standing counsel, Water Resource Department, and Ms. A. Gayan, learned CGC, have however raised an objection that the works are of 2012-13, 12 to 2012 and 13, and the liability statement is not issued by the chief engineer, which is one of the requirements laid down by the honorable full bench in the case of so-and-so. And civil court. You can go to the civil court.
Lordship, I may be allowed to.
We have we'll say this.
Okay.
Civil court or here to Diba.
May I please, Your Lordship? Scheme was liability is page 22. And my technical sanction is annexure 1.
22.
My-
What is 22?
That was issued by the executioner
Hmm?
to the petitioner. My technical sanction is there, administrative approval is there.
What this executive engineer will not do?
My technical sanction is annexure 1.
That is not a requirement. We are not on the how we have done the work. We are on the aspect of admission of liability, acknowledgement of liability.
And my the administrative approval is there.
We are not on those. Work might have been done by following all the due process. But to entertain by a writ court, you need to follow Tamser Ali.
No delay. Work order issued in 2016. And my lord, administrative approval is.
There is a delay, madam is right. Delay as per Tamser Ali. You go to the civil court, same order. Arts repeat Talukdar, learned counsel, for we cannot. You meet Tamser Ali, will dispose it of. You have not met the requirements of Tamser Ali. You meet Tamser Ali, there is no problem. You go to the civil court. Khali ate heri nahoy. Wow. Ki RTI nahoy. Liability statement which is not signed by the executive engineer. Then it will. Okay. And who are the who's appearing? State of Assam Chief Secretary M. Chetia. M. Chetia, then R. Deca, Standing Council River, Water Resource. And Madam? Okay. A. Sharma. B. Chakraborty. No, you see not your name. A. Sharma. We know your name. A. Sharma on behalf of B. Chakraborty. Huh? Okay. We give you liberty to approach the civil court which is permitted by law. Same. 52 also. Respondents are the same. Okay. 52. Khali RTI nahi, huh? Yes. What is it about?
Cancellation of contract.
What is the stage now, Mr. Sharma? What is the stage?
That might have been terminated.
No, that we know. Thereafter.
Thereafter, they have floated phase tender for the remaining work. Obviously, I cannot participate in the tender for this in scientific concern. And as on that, I don't think that the work order has been issued in the phase tender for this. So by way of this petition, even though I have paid for a
final prayer for cancellation of my termination order. An interim prayer is made to take the proceeding of the phase tender, your lordship.
That perhaps will not do. But even assuming you make out a case, we interfere, then what will you get? You can at least get an order to go to a civil court for damages.
Actually, in this case, what has happened by final the completion date, there are two phases of the work as per the respondent authority. Phase one, the final.
No, Mr. Sharma, we are on a different perspective. You make it a you make out a case for interference. In the meantime, work is done, but we find that we arrive at a finding that it was illegally terminated. Then what relief will you be entitled to from a writ court?
My submission would be, since the final completion date is 9/3/2027, I have sufficient time to complete the work. The final completion date is 9/3/2027.
But we will not halt the order. We can give you a short notice.
Yes, madam.
Madam, you come up with instructions.
My
Okay.
lord, kindly, termination order was issued on 9/11/2025, my lord, and he approached before now only after 11, my lord.
There was delay. I can explain, your lord. I have made categorical.
No, even explanation will not do. There has been sufficient time has elapsed in the meantime.
So there is another aspect for which I had to refile this petition. What has happened, your lordship? After this termination was cancelled, I participated in.
Termination was not cancelled. Contract
Sorry,
was cancelled.
contract was continuously terminated, your lordship. I participated in another contract tender process in Leh, Jammu, your lordship. There, what has happened? After I submitted the bid as a joint venture in the capacity of a joint venture, I came to know that my technical bid was rejected because on periodically every quarter the respondent authority comes up with a statement regarding workload of all the contractors, the workload, the capacity of the contractors to carry out further work, your lordship. In that workload statement, there is adverse remark put against my firm as slow progress, your lordship, because of this tender, which is under challenge. And since there was a slow progress report in that particular quarterly report, your lordship, my late contract was also cancelled. Technical bid was cancelled only on that ground. So I'll be further aggrieved by this particular adverse remark, your lordship.
Okay.
That may be stayed, your lordship. Only the adverse remark part.
My lord, sometime maybe you
That
have
I
to
can-
take instruction.
So, your lordship, that if delay, your lordship,
My lord.
at page 296, if your lordship may kindly come to 296. That part will be said. I have to interview.
My lord, that work was commenced on 25 March 2024, my lord, until date of termination, his.
No, we are not saying this. We are not saying this. Heard Sri P.K. Sharma, learned counsel for the petitioner who has put to challenge an order of termination of a contract. Order of termination dated 4/11/2025 of termination of a contract. Full stop. It is submitted that such termination is arbitrary and unreasonable and has been done without taking into consideration the relevant aspects. Full stop. The learned counsel has also informed that because of this termination, the participation of the petitioner in tender process floated by the Union of India.
Yes, my lord.
No, not for the other works you said, lay work.
That is not for termination, that is for another quarterly. report
Understood. By whom?
By
You-
MES only.
By the same organization has been adversely affected. Full stop, para. Let notice be issued, returnable on returnable on 18th of September. Ms. A. Gan, Learned CGC accepts notice on behalf of
All the rest.
all the respondents. Let extra copies be served upon her within 2 working days. Full stop. Sri Sharma, the learned counsel, prays for an interim order. Full stop. The same is, however, strenuously opposed by the learned CGC by citing that the termination is of 4/11/2025 and the approach to this court has been done after a considerable length of time. Full stop, para. While this court is not inclined to stay the termination order or the allotment of the remaining order, comma, it is provided that the aforesaid termination shall not be a ground for rejection, for rejecting the bid of the petitioner in other works in the technical evaluation. The aforesaid interim order would however be reconsidered on receipt of instructions. Mr. Mazumdar, what is this?
Non-payment of contextual fees, my lord.
Where acknowledgement? Acknowledgement. 13.
13, one, my lord. It's a joint, my lord.
No, by whom?
This is by.
Physical verification will not do. There has to be an acknowledgement of the liability in writing by the chief engineer or head of the department.
Completion.
Those will not do. Those will not do. We are not of code of facts. We can entertain only on very, very limited, when you fulfill the requirements as laid down by by the full bench. Verification, this can be matters in the civil court, not in the report. He approves the civil court. Hertz v. P.K. Mazumdar, learned counsel for the petitioner, who by means of this application has prayed for a direction for release of contractual dues. Full stop. The learned counsel has relied upon a joint verification report, which is signed by the assistant executive engineer, executive engineer, and assistant commissioner. Full stop. Para. Miss R. Deka, learned standing counsel, Water Resource Department. Also heard Miss, who are there? Also heard Miss R. Deka, standing of Water Resource, Finance, H. Alia, standing counsel Finance, and Sri M. Chetia, learned State Council. Full stop. The learned counsel for the respondents have, however, submitted that the petitioner has not fulfilled the requirement and the principles endorsed by the Honorable Full Bench in the case of so-and-so. Liberty to approach the civil court.
Supplementary list. Just for that's all. Some
50 is for motion.
My lord.
Yes.
Some facts were not placed before this honorable court in the repetition, my lords.
They're snatching our meter.
Yes, lord.
What has happened?
This is a case of theft of electricity.
Oh.
I have written instructions. The petition, we had visited his house in August 2025 first. It was seen that in his father's meter, there was an amount of 1 lakh odd which was pending. So since dues are fixed to the premises, he was given a notice to pay the amount. He did not pay. It was disconnected in September 2025. Then he illegally reconnected again. Again we went, again he disconnected. Then finally on 17/4/2026, we came to know that he had again reconnected. On 12/8, we went, we had seen that it was connected illegally. And then we seized the meter. He refused to sign the seizure report. On the next day, he has submitted a representation. Now he's trying to conflate both the two issues together. And these are the written instructions.
I'll highly decline.
And under 135, we are proceeding to register the FIR today, my lords. I have instructions to that effect.
The case, you have to register an FIR in this part.
That disconnection is mandatory as soon as it is detected. So it was done. He has taken administrative approval for the FIR, which has been granted.
Hertz v. G. Chamo, learned counsel for the petitioner. Full stop. This matter was listed on 26/8/2026, and considering the grievance which was relating to discontinuation and removal of the electricity meter box by the APDCL personnel, Sri K.P. Pathak, the learned standing counsel APDCL, was directed to obtain instructions. Full stop. Sri Pathak, on receipt of instructions, has however submitted that the correct facts have not been projected at all, full stop. He has submitted that there has been instances of theft of electricity for which there was a disconnection. And on 2 instances, the petitioner had illegally got the connection. And finally, the meter box was seized, and the petitioner had refused to sign the seizure report. Full stop. He has also submitted that an FIR is on the process of being lodged against the petitioner. Para? Yes, what do you do? What will you do now? What will you do?
Already I was.
You have this on affidavit, we'll dismiss this.
Very well.
Okay. This court is of the opinion that the aforesaid facts be put on record by way of an affidavit, which is to be filed within a period of 2 weeks.
Very well.
Let this matter be listed for motion for consideration of all the facts. We'll have it on 14th of September. You can take this back if you want. If it remains, also let it remain.
He is the counsel for the petitioner. He is in the legal day today.
We'll have some other day. Okay. On a request, Monday, but Kali khula nahi ki? Wednesday we'll have. On a request made on behalf of Sri P. Sundi, learned counsel for the petitioner, matter is adjourned to be listed on Wednesday. Thikiajuli matter.
Yes, sir.
Furniture shop.
I'm not aware.
We are aware. When you see a furniture shop, it will be Thikiajuli.
Yes, that is famous.
Not barely famous. Lot of actions are being taken.
For the cane furniture.
No, even for furniture, Thikiajuli is very. Sri S. Sharma, learned counsel for the Forest Department, is present. Wednesday call no? Private heart. Item number? Motion. Then what happened?
Suddenly, Lordship, block development of the fish especially the input letter, Lordship, by which it was directly to closer of the fictions. Is the livestock market.
It's a cattle market. Yes, what?
Lordship, I think he seems to be also challenging the very power by which private markets can be allotted. Lordship will allow me to file an affidavit in the meantime. Should may issue notice.
No, but how do you, prima facie he's making out a case?
Yes, Lordship, one more aspect that the order has already been issued on 29/7. Since then that other.
24/8.
24/8.
No, Lordship, the authority was issued on 29/7. So what is on 24/8?
29/7, what happened, my lord? Within, my lord, after 13 kilometers of distance from the present my market, one another Shunapur cattle market, that was Lordship, settlement was given was. And on that count, Lordship, my market was directed to be closed. My market is.
Mr. Atreya, you take instructions. We'll have this on Friday next or Wednesday next for motion. Because he's praying for an interim order.
Yes, yes.
And we may be inclined to grant an interim order.
Lordship, I'll get instructions.
The pilot market there.
Huh?
Market.
One day you'll have to suffer.
Yes.
Only one day. Wednesday we'll have. Sunday we cannot hold court. On Wednesday.
At 2 if possible, my lord, because.
At 2.
If possible.
It will not be possible. Second half, this court will have difficulty. This court will not be there 2 weeks. So we have to sign all the orders. Second half will not be possible. Wednesday, we'll consider because we have an interim order, interim prayer. Okay. Heard. 3. N.H. Borbia, learned counsel for the petitioner who is aggrieved by an order dated 24/8/2026, whereby his private cattle market has been closed, has been directed to be closed. Full stop. the learned counsel has questioned the jurisdiction of the respondent number 5 to issue such an order, and has also alleged mala fide. Puts the para. Sri A. Atria, learned standing counsel BTC, is directed to obtain instructions. Full stop. The matter may be listed for motion on Wednesday next. Wednesday, when date 2? Second. You have the instruction.
Yes,
Give a call to facilitate the learned, to facilitate the learned standing counsel to have the instructions, comma, let an extra copy be served, extra copy of the writ petition be served upon him during the course of the day.
Very well. Okay.
Item 19.
Yes, Mr. Chakraborty.
Neglected amount of weight losses has successfully heard the matter. Last occasion also.
Mr. Chaudhary, PWD. B. Chaudhary. Where is he?
17-7 order lodging in NST Nagar. The PWD has filed the affidavit clearly saying that
CCC.
the what amount is due. Only thing they say that
Oh, I understand that office, labor office, consolidated.
side of it.
Okay. Okay, Wednesday. Okay. Do Sri B. Chakraborty, learned counsel for the petitioner is present, comma. There is none to represent the Public Works Department. And CCC is the party.
No, CDC is not.
Public Works Department, para. In the interest of justice, matter is adjourned to be listed on Wednesday next. Wednesday, this court, however, will not be there, but nonetheless. CC, not again. CC, don't night.
20.
Tulip.
In this case, my lord, we have received instruction, my lord, will file an affidavit.
What is this matter?
Inter.
Okay. Okay. Sri M. Chetia, Learned State Council has submitted that instructions have been received, and he prays for time for filing the affidavit in opposition, para. Matter is accordingly adjourned to be listed on when? 23rd of September?
Yes, ma'am.
23rd of September. By which time the affidavit is required to be filed. Next.
21 to 27.
Yes. Mr. Upadhyay. Mr. Chakraborty, what is this?
Lordship, regarding payment of wages act, Lordship, may I pray that Lordship may take up item number 27, Lordship. In that matter.
Item 27.
27. Item 27.
Now, are you ready for the matter today?
Small matter otherwise, Lordship.
Huh? Why? Today is difficult for you. Then we can proceed and dispose of the matters.
Only issue, Lordship, the authority has given us payment of wages, as per Payment of Wages Act. They're claiming that controlling authority has not don't have the jurisdiction to entertain the claim filed under section 15. That is it, whether claim can be entertained or not. And one more thing is their Lordship, against the order of the controlling authority, appeal lies, Lordship. They have filed an appeal, they withdrawn the appeal, then came to this.
Because this court has no jurisdiction. So there are certain judgment of the Supreme Court and the High Court. That's has to be cited. So that will be kept on the hearing date. It's
Okay, Thursday next. Let him be satisfied. Okay, Thursday next. Heard Sri N. Upadhyay, Learned Counsel for the petitioners. Also heard Miss M. Chetia, Learned State Council, Miss R.D.B., Learned CGC, all of you, different. B. Sharma, then Gayan for, no, you're for Gayan, huh? In all these cases, that's what. And as Chakraborty for?
Respondent for lordship.
In all the cases. And
All the cases.
Full stop. The learned counsel for the parties are in agreement that the matter can be taken up for disposal at the admission stage. Full stop para. List for admission hearing on Thursday is a working day.
Lordship.
3rd of September.
Lordship, may I press 17, lordship? I have some difficulty.
8th of September, 8th.
Is a Tuesday, lordship.
Tuesday. 8th.
Lordship.
8th September. 8th September.
Lordship.
ಈಗ लिखी बात से
Item 30.
30.
My lord, I am for respondent number 2 and respondent number 3. My lord, I humbly seek further time to file a affidavit in opposition.
Why haven't you filed? You were given time on 29/7/2026. You are Sen Gupta.
Yes, my
You
lord.
were granted time.
My lord, we are preparing it.
Madam, some more time. Okay. Your name? K. Bhattacharya. Heard Miss K. Bhattacharya, learned counsel for the petition of para. 3S Sangupta, learned counsel for the respondent numbers 2 and 3, has renewed his prayer for grant of time to file the affidavit in opposition para. Matter accordingly stands adjourned to be listed on 18th of this September, by which time the affidavit in opposition is required to be filed. 18th September, file it before that.
Item 31.
This matter I am appearing on behalf of Custom Google. In its terms, time to file.
Who? K. Gogol. Madam, what is the matter? Interim order, you are covered by an interim order. Okay. Heard. Several respondents. They have filed or not? Okay, let us see. Your A. Bhuya. Heard Miss A. Bhuya, learned counsel for the petitioner. Para. Sri G. Bukolia, learned counsel, has however prayed for time on behalf of Sri K. Gogol, learned counsel for respondent number 6, for grant of time to enable filing of affidavit in opposition. Para. Matter accordingly adjourned. Accordingly stands adjourned to be listed on 18th of September to enable filing of affidavit in opposition. Full stop. Interim order passed earlier stands extended till the next date of listing.
Item 32. Matter pertains to non-payment of material bill.
Non-payment of material bill. PWD, PNRD. PNRD. Madam Datta, where is your friend? After a while. Where is Miss Thapa, Mr. Datta, S. Datta? After a while. 33 are the same. Okay.
Supplementary. 58.
Who is your senior? S. N. Nath. What is the matter, Mr. Sharma?
Your Lordship, it's regarding certain arrears of pay, PHC matter, Your Lordship. Work orders.
You have filed affidavit?
Yes, Your Lordship. Tamshir is to be applied in this matter, Your Lordship. In the last year also, they had short time. There was two.
No admission of liability.
There is no liability, Your Lordship. The work orders.
This cannot, where is he? Ask him to come. We'll dispose this off. Be here. It was a work hackathon.
59.
$59.
I have.
Other side. Other side. DJ Halui. Last occasion on time was taken on behalf of Mr. DJ Halui.
On the medical.
Unwell. Okay, fair. None appears for the petitioner on call, whereas Sri M. Chetty, London State Council, and Miss M.D. Bora, London Standing Council, Transport Department are present. Para. In the interest of justice, matter is adjourned to be listed. 3 weeks? No. Listed. Matter is adjourned to be listed on 9th of September.
Our name may be reflected in the constitution.
Names not reflected.
Yes, ma'am.
Names of GA Assam be reflected in the cause list. Transport reflected.
Yes.
Item 24.
I request kindly take the matter after some time.
After a while means after a while, we will not sit in the second half. Ask him to come now. Okay, after a while. What is the IA, Mr. Botakur?
My lord, the contempt arises out of verification of work, my lord. We have already done the verification. They have, my lord, moved this IA saying that there has been perjury, my lord. All baseless IA. We have replied that on record a verification was done, and on that basis the affidavit was filed. Absolutely, my lord, baseless allegations, my lord, they are raising in the IA.
Yes, Mr.
The IM was filed a direction for perjury. What has happened was there was an order for initiation of a exercise by them, by which entitlement was to be.
That IA has been responded to.
Yes, we have filed an objection.
We will have to hear this.
Yes.
When do you want? We have this on 3rd of September.
Can
8th of September.
Yes.
On a Tuesday.
Yes.
Okay. Heard Sri S. Datta, London Senior Counsel for the applicant / petitioner. Also heard Sri I. Botakur, Learned Counsel for the respondent number 1. Full stop. Sri Botakur has submitted that objections have been filed in the IA and that the allegations are also without any basis. Para, let this matter be listed for consideration on 8th of September.
Item 35.
Lordship. Although on the last occasion, I prayed for some time, Lordship. We have sent a proposal to the finance department for.
There is some movement, Mr. Suleiman.
Lordship.
Heard Sri J. M. Suleiman, Learned Counsel for the petitioner. Full stop. Sri R. M. Das, Learned Counsel, representing the respondents, has submitted that instructions have been obtained as per the order dated 22/7/2026. Full stop. By placing the written instructions dated 27/8/26, the Learned Counsel has submitted that the proposal have been submitted to the Finance Department for the two works on 24/8/2026 and 17/8/2026 respectively. Full stop. Considering that some steps have been taken towards compliance of the order in question, comma, the matter is adjourned to be listed on 25th of September, on which date updated instructions are directed to be placed before this court. Yes. Same, same rated instruction. Okay. You were given time earlier also. Ms. P. Thapa, Learned Counsel representing the Public Works Department, has renewed her prayer for grant of time to obtain the instructions / file affidavit in opposition. What about you? Last time you said that instructions were received. Also heard Sri G. Bukolia, Learned State Council, Para. In view of the above, matter is adjourned to be listed on 23rd of September to enable obtaining of instructions.
Similar.
Same, 33 same.
Item 37.
Mr. Mitra, Mr. Bhagavati, R2.
Lordship,
Contempt matter.
content matter, Lordship.
You are there.
Financial sanction was given, Lordship, whether they have received or not, that is not known.
After some time means not
Lordship,
in the
maybe
court.
on another day,
Huh?
I also have some problem.
No, we'll have it on Wednesday then. Wednesday.
Lordship.
Okay. Sri M. Bhagavati, Learned Counsel for the respond number 2. Please for some accommodation. Full stop. Also heard your name? Sri A.K. Borua, Learned Counsel for the petitioner, and Sri G. Bukolia, Learned Counsel for the respond number 3 and 4. 3, 4 and 5. 3, 4 and 5. Para. Matter is accordingly adjourned to be listed on Wednesday next.
Lordship, financial sanction has been given, Lordship.
Okay, on Wednesday you place it before.
Item 38.
Here in this case, my lord, I'm entitled to 10 marks, my lord, I have given 2 marks. In similarly situated person, my lord, they will give it 10 marks. So, my lord, your lordship would be pleased to see the similar certificate.
But we have given a direction for giving equivalent marks.
2 marks has been given.
Yes.
Thing is this, my lord, subsequently I got certificate copy, copy of experience certificate, similar experience certificate, 10 marks.
But these are subsequent documents. Can it be a ground of, and this recruitment process was over when?
In that case, my lord, in 25 also, in 15/5/2025, your lordship also.
15/5/25. Now we're in 26. 1 year has passed.
Whether I get appointment or not, my lord. It may be academic one, but the discrimination against me, my lord, that may be replaced. Because 10 marks.
Okay, we will require some consideration. We'll have this after 11th. Okay. By means of this application, Sri, the petitioner represented by the applicant represented by Sri M.A. Sikh, Learned Counsel, has prayed for a review of the order dated. Is it 10/5? 10/5/2024, passed in WPC 4156 of 2022. Full stop. The said writ petition was on the subject matter of recruitment, which was pursuant to an advertisement of 2017, full stop para. Though, in the considered opinion of this court, the application, even if is decided in favor of the petitioner, would be mere academic comma. Sri Sheikh, the learned counsel, has submitted that he would like to press the same. Full stop para. List for consideration on 15th of September.
Item 39.
Heard Sri NNP Chaudhary, learned senior counsel, assisted by Ms. Kede, for the petitioner, who has referred to the office notes. Full stop. As per the last office note dated 26/8/2026, comma, neither ready card nor unserved notice has been received back. Full stop. Considering that the notices were issued on 3/8/2026, comma, the matter is adjourned to be listed on 11th of September, not 11th, on 16th of September, to enable fresh service report, to enable the office to give fresh report on service.
Item 42, 42.
শুনিছিলে তো Rakhi is over. The celebration is over or not? So if we decide against you, will there be a celebration? You're in a bad position today, taking a huge risk. Suppose it's in your favor, then double celebration. But if it's against you, then are you serious with the matter? But Mr. Chaudhary is very serious. Interim order is there. Okay. Let us complete it. We have heard this. Let us first let's have a look. There was an NIT. You participated. Bid was rejected on formation of cartel. Representation not accepted. Show cause notice for blacklisting. You are not on the forfeiture of, you are on the aspect of rejection and forfeiture, not on blacklisting. Your explanation is that in your place there was a Durlab Gogoi who gives online service, and all of you have taken his service, and he's giving such service for more than a decade. So first problem was IP address was the same, CA was the same, appendix were all identical, and Gopal Agarwal and BK Agarwal are brothers. What else is required?
Whether this simulates it's the same person that might have uploaded the bid malware, so there are some common mistakes are there. Whether this will
See, we would be more interested in the objective satisfaction which they have arrived at before taking the decision. Can we go deeper into it? Aren't there enough materials to take the action? Unless you say these are all taken with a malafide intention. A reasonable person with these materials can he come to this conclusion or not? If this is one of the plausible conclusion, then we'll not substitute the conclusion. That is our limited role as a writ court. If it's a possible conclusion, and this is one of the possible. Five numbers of reasons have been prescribed. All five appear to be acceptable reasons. You may have another view, but with another view itself will make a decision illegal.
That will not amount to betraying or in forming a cartel. These are one the IP address since it is uploaded from the same service provider.
That now we have your explanation. It's a common practice to avail services of Durlabh Gogoi. Lack of expertise, others have also availed. It's a mere coincidence, not a cartel.
CA certificate, since it is issued by the same CA, that's why the certificate is same. But the contents therein is not to disregard on the basis of our.
But aren't you required to take that? We pondered about the matter. When you are fighting, when you are competing against yourself, didn't you think fit that I have to go to a different CA?
That is who is providing full certificate matter. We are taking the services of CA matter, and we suppose a person gives a certificate.
That is difficult to be digested or accepted.
While taking the services, he has given the certificate to any other person or not.
But ultimately, these are given. This may be mere coincidence, but the decision, the conclusion they have arrived at are based on objective satisfaction. Whether we can replace those, substitute those.
Only since the same certificate or same, it is not going to make any difference in the work or in the tender. Because these are formalities which have to.
So it's not a question of making a difference in the work or the tender. It is on the aspect of the rejection of your bid on the ground of forming a cartel. And these 5 numbers of grounds, according to the respondents, are enough to form an opinion that there has been cartelization. If the grounds were very vague, or some grounds which a reasonable person cannot take, then a writ court. But these are objective in nature. There are materials from which this satisfaction can be arrived at. There can be, we have already said, there can be under interpretation that Mr. Mishra is not aware which CA you have gone, or going to the same person for bidding Durlabh Gogoi may not be a fault, or may not be an ingredient to assume cartel. We have noted your explanation. We will answer your explanation. We'll hear if there is anything else. Mr. Mishra wanted to add something.
Only one bidding, what is bidding?
Which one? Vatsa?
Rajasthan cylinders, that is airline 2018.
Air? Seven, 3, 6. Name? Rajasthan. Paragraph 18.
Paragraph 75.
75. 75. Wait. Necessary ingredients of bid rigging. Okay.
Next page, my God.
Mr. Mishra, anything you'd like to add? Don't repeat. We have, don't repeat what your colleague. Which one? Which one? 114. Vijay Kumar Agarwal. গুচাই দিয়াচোন।
Page number 233.
233. What is this? Hmm?
How work could distribute? Yeah, my lord, one cannot get a work distributed among 6 bidders, man.
Mishra in WPC. What is your repetition?
1.4.
26. Page 233. Work distribution methodology. What is there?
Table, my lord, it says.
Just a minute, Mr. Das and Mr. Roy, which matters? Second half, we have a problem. This code will not be there 2 weeks. We have to finish off the matters. We'll have some dates. Unless very urgent, we'll give some dates.
Some other date.
Mr. Das, which one?
60 something.
Supplementary motion?
Motion orders.
Orders? Orders, why are you here?
No, I'm for the other side, because there is some interim order to be.
Vacated?
I have been asked to appear for the private respondent.
Who's for the other side? And but I will have some other day.
Okay.
Today, we'll hear Mr. Chaudhary and complete this matter. Huh? Which one? We'll give a date. Without hearing, we'll not give you time. Next Wednesday it will come. Then you can pray for time. Okay? Okay. Madam, just give the date too. Okay. Other matters will give dates. Okay. Yes.
Sorry, Mr. Item number 21 to 27, there is an interim order.
What was the matter?
That is mentioned as matter of the.
Huh?
Payment of wages act.
Payment of wages. Oh, Mr. Chakraborty.
Yes.
Okay, interim order passed earlier to continue. Silence. Oh. Please, 5 minutes will give, because he needs to be given some time at least. Huh? 30 bidders were there.
He cannot form a cartel, man, first man.
Hmm?
Out of 30 only, he cannot form a cartel, first of all, man, because this work to be distributed among 6 bidders, man.
Amongst
6 bidders.
30 bidders were there.
So they are from 6 bidders, man.
6 bidders.
Yeah, 3. Yes, there is the allegation of cartel, man. We cannot form cartel against 30 bidders, man. First, man. Second, you will see my distribution of chart, my lord. First, my lord, L1 will be, my lord, who has quoted 20% of the work, my lord. And others should have had to meet the date of L1, my lord. And if proceeding is placed to 34, my lord.
Hmm.
And maybe clause 4, my lord.
$234 plus 4 in case of.
In case of.
Hmm.
Of more than one bidder having quoted same percentage, then the ranking of such bidders shall be decided based on single highest executed work value of technically accepted submitted works as per these. The bidder with single highest executed value of work submitted among the bids shall be ranked higher. After clause 5, after ranking is finalized as mentioned in L2, as mentioned above, L2 and subsequent bidders shall be asked to match their quoted percentage with L1. Quoted percentage. The order of preference shall be based on the original ranking of bidder L2 followed by L3 and so on. In case any bidder does not accept to match L1 quoted percentage, then ranking will shift automatically to the next techno-commercial
commercially qualified bidder shall be given an opportunity to meet his rates with the L1 product procedure manner. My lord, now my lord, suppose therefore my lord, there cannot be cartelized in manner. We have quoted 16%. We have to match our rate, my lord, as per L1. We don't know who will be L1 man. And in this our case, the price has not been open match. Therefore, my lord, under this work distribution system, my lord, there cannot be formation of the cartel man. There may be some similarities, my lord. Even if we suppose my lord, we have quoted same rate, everything same rate, even then we not get your work, my lord, because it has to be follow this chart, my lord. So therefore, formation of cartel does not, my lord, arise. 30 bidders, 3 of us here, my lord. And one of the reasons is that we are brothers, my lord. No, we are brothers, my lord, but we are separate business entity and we are following separate things, my lord. As best time, Mr. Gupta.
To answer this submission straight away, all this, that page 233 and 234 that has been placed, these all pertain to the price bid. They did not even reach that stage. They were ousted at the technical evaluations.
No, that is what,
But that is all besides the point, Mal.
no,
Your
no,
Lordship is examining
no,
the,
no, he is saying that it is only on the consider evaluation of the price bid that they may get an advantage. Being technically responsive will not entitle to them to have the work. They have to compete in the price. And in this methodology, the allegation of forming a cartel perhaps with these materials will not make any difference. That is what he's trying to project.
that is what he's trying to project. But what has happened is, only 3 are before your Lordship. There are 15 in respect of which this allegation is there, cartelization. The other 12 have not come.
That was the question we are about to ask Mr. Mishra and Mr. Gupta, that if Mr. Durlabh Gogoi is the only person, how did the others go to have their bids submitted?
15, there were 30 bidders. 15, we found that there is no such allegation of cartelization. There are no similarities. But in respect of the other 15, we found that there are very serious instances of cartel formation. In fact, my lord, there are some relevant aspects have not been placed before your Lordship, but that will clarify the position. But before I address your Lordship on the merits, one aspect, my lord, they have given up the challenge to the blacklisting proceeding. So at least that leave can be granted to us now.
Yes.
Now, there are 2 important facts which have not been placed before your Lordship. The tender process has been finalized long back, my lord, and contracts were awarded on 11th of November 2025 itself. They have not made any amendment to the writ petitions. Even to enter into an adjudicatory process, those 6 successful bidders become a necessary party now.
But these were instituted in 25.
Instituted earlier. There was no interim order. We finalized. And as far back as on 11th of November 25, contracts have already been awarded to 6 successful bidders. Now, my lord,
yes,
if your Lordship takes up our affidavit in opposition, what has happened is, of late, across the country, this cartel formation has become almost like a habit amongst tenderers. So the Competition Commission of India has issued a set of guidelines, and we are guided by that. If your Lordship will take up our affidavit in opposition, in 114 itself, in fact, I have made my preparations in WBC 114 only.
Which paragraph?
If your Lordship, we have annexed the guideline itself.
Which page?
Page 284.
This is by the CCI.
CCI.
284.
284. They call it a diagnostic toolkit towards competitive tenderers. Now, if your Lordship kindly turns to page 286.
It starts at 284.
It starts at it's a very bulky document.
Yes.
We have only annexed the relevant portion.
Yes, yes. 286.
286. At subclause Roman 2, your Lordship will find the heading warning signals in documents.
Yes.
And your lordship will look at the first bullet point. Bids were prepared by the same person or were prepared jointly. Number two, identical mistakes.
Mm.
And it goes on and on. We are concerned with mainly first and second, and then your lordship turns to page 287. The third bullet point. Bids submitted by firms are sister concerns. Here, they are admitting that they are brothers.
No, sister concern and being brothers, they may have different type of business. Sister concern business will be similar.
No, but the additional facts that they went to the same CA, the fact that they went to the same service provider,
Those are there.
everything adds up. Now, my lord, fifth bullet point. So again, talks about similar mistakes.
In third, where is the sister concern?
Third bullet point, bids submitted by firms are sister concerns.
No, third, warning
Or have common
signals.
directors in the board of directors or having more than 50%.
No, which page are you reading?
Page 287.
287. Different less than submitted. Oh, sister, okay, 287. Okay. Third bullet point. Okay. 287.
And again, the fifth bullet point.
Yes.
Again, talks about similar language, similar mistakes,
Mm.
etc. And then the last part one, your lordship will kindly see. Bids received from the same IP address. So, an expert body like the Competition Commission of India is saying that a bid received from the same IP address is a clear indication of cartel formation. And we are guided by these guidelines. That is why, my lord, what we have done, if your lordship comes back to the writ petition, we have incorporated specific clauses in the tender NIT itself. If your lordship comes back to the writ petition, first your lordship will have the NIT starts at page 22.
Yes.
It starts at page 22. If your lordship will kindly turn to page 33. In fact, page 32 talks about what are the documents that comprise the bid. And if your lordship turns the page to subclause F, relevant are subclause F and subclause G. F says that integrity pact applicable for tenders above 1 crore. So they have to sign an integrity pact. I'll take your lordship to the integrity pact itself. Now, G, the bidder should submit an undertaking as per appendix BP1, BP2, and BP3 on acceptance of ONGC's policy for banning provisional suspension of business dealings, etc. Since this is also an incidental issue. Now, if your lordship will kindly turn to the integrity pact itself, which is at page 227. Specific format is prescribed. It is an appendix to the NIT 227.
Yes.
And if your lordship turns the page to 228,
yes.
Section 2, clause 1. The bidder contractor commits to take all measures necessary to prevent corruption. He commits himself to observe the following during his participation in the tender process and during the contract execution. Subclause B. The bidder contractor will not enter into any agreement or understanding with other bidders in connection with the bid, including but not limited to prices, specifications, certifications, subsidiary contracts, submission or non-submission of bids, or any other actions to restrict competitiveness or to introduce cartelization in the bidding process. So he has given this undertaking. Now, if my lord comes to page 178, this provides for the tender evaluation criteria, technical evaluation, how the technical evaluation will take place, and what are the aspects that will invite rejection. And if your lordship turns to 183, your lordship will find
183.
Hello. Subclause H, small Roman 2. Offers of bidders violating the provisions of the Integrity Pact.
Yes.
This is a criteria which invites rejection of bids.
Hmm.
Now, there is also another aspect, my lord. The tender itself provides for an appellate mechanism that if any person is aggrieved by the tender evaluation process, there is an external monitor. This is an independent body under the tender that your lordship will find at page 230. Page 230, section 8 provides for, in fact, page 230 read with pages 39, 42, and 43. There is a mechanism prescribed basically there is a independent body to whom, in fact, the writ petitioner in this writ petition, 114, he approached this authority and they have also examined the whole decision-making process by the ONGC and have rejected his claim. The other two did not approach. And in fact, the IEM's decision, the detailed reasoned decision, your lordship, I'm not troubling your lordship because of the paucity of time. Your lordship may just make a note, my lord. The IEM's decision is at page 289 of the affidavit in opposition.
What is the date?
It is dated.
This is qua the petitioner in
28/10/2025.
28/10/25. This is qua the petitioner in 114.
114.
Others did not.
Others
okay.
did not avail of this.
They were unsuccessful with the IEM. 114.
114.
Were unsuccessful with the IEM.
They have given a reason, passed a reasoned order.
Okay.
Upholding the decision-making process adopted by the ONGC. So faced with this kind of a situation, and particularly when the contracts have long since been awarded, whether your lordships would at all, and what has fallen, I'm not troubling your lordship with those judgments. Silpi is one of the recent ones, where it has been very categorically held by the apex court that your lordships will not substitute the decision. If your lordship so desires, I can give the citation. I won't trouble your lordship. Silpi is 2020, 16 SCC 489, and the relevant paragraph is para 20. And your lordship recalls the Cochin International Airport case, where the Supreme Court went to the extent of saying that even if a legal point is made out, Cochin International
Shilpi is paragraph?
Paragraph 20.
20.
And Cochin International Airport is 2000, volume 2 SCC 617. And relevant paragraph is para 7, where the Supreme Court says that even if a legal point is made out, your lordships will not interfere. In fact, since then, NG projects has gone even further.
But NJ was somehow diluted in the, what was the name of the decision? Forgot the name. Ganesh or something. Jai Ganesh or something.
Like that. Your lordship wanted the date of the IAM.
IAM 28/10/25, you have said.
28/10. So therefore, my lord, in my respect, and the similarities are glaring. In fact, they have, if your lordship just takes up page 292 for a moment, my lord, affidavit in opposition. This spells out the glaring similarities.
292.
They have summarized the similarities. This is by the IEM's, this is part of the IEM's decision. Page 292 at clause 5.3, para 5.3, your lordship will find they have A, B, C, D, they have summarized the glaring similarity. All the three bidders submitted so-and-so certificate from the same chartered accountant. All the three bidders have not submitted self-certificate, MII certificate. Same mistake by all. All bidders have filled appendix so-and-so in same style. Same portion of the appendix BP2 is highlighted in red by all three. They also made the same error in appendix BP2 by mentioning the date of signature as 22/3/25, whereas the NIT was published on 16/5/25. Date mentioned in appendix BP1 so-and-so are said. All the undertakings were provided individually on single page in similar style. Proprietors of so-and-so are brothers. So, having objectively analyzed all these things, a decision has been taken to reject. And the entire decision-making process, as prescribed in the NIT, we have followed it punctiliously. And your lordship recalls, in G.J. Fernandez, Supreme Court said that the authority inviting the tenders has the right to punctiliously follow each and every detail in the prescribed in the NIT. We have gone strictly by what the norms that we have declared. So in my respectful submission, my lord, therefore, no fault can be found in the decision-making process, my lord. Therefore, the petitions are liable to.
There's no interim order pending.
Interim is that we will not finalize the blacklisting process
That
without the leave. That challenge they have given up.
Okay.
Our difficulty is, my lord, some of them have been participating in other tenders also. And those tenders we have had to hold back.
Mr. Gupta, Mr. Misra, so far as blacklisting is concerned, we have held in the first date that these are separate causes of action. Are you seeking leave to challenge the blacklisting? You have to tell us. Otherwise, if you close this, either in your favor or against you, you will be precluded from challenging. It amounts to answering it. You have to tell, you have to take leave.
My lord, my young friend here points out another vital fact. My lord, the tenders were finalized and the contracts were awarded on 11/11/25. And all the three writ petitions have been filed after that. Apparently, Gopal Agarwal was filed on 22/12/25 and Hitesh Datta filed on 17/12/25. And Vijay filed on 6/1/26. So this was a fact which was known to them at the time of filing of the writ petition.
No, contracts were given on 11/11/25.
Right.
Writs were moved thereafter.
Thereafter. So therefore, these six definitely become a necessary party. And there has to be a challenge to the award of the contracts.
Okay. Okay, we'll consider. Okay, Heard sober naam likhe diba. You please give the names where you are appearing. And also heard Sri I. Chaudhary, Learned Senior Counsel, assisted by Sri P. Barwa. Para, hearing is concluded. Judgment is reserved. Okay. Kuntu.
Oblige.
Yes. Ki asil, no? What is 58?
It's with regard to the work orders. They did the last work order of 2020. They have just approached the court in 2026.
Yes, this is not maintainable.
Lordship, our petition, in paragraph 2, we have mentioned and what annexer also has been annexed there, that my contract certificate was up to 19/5/2023. Then we had issued one legal notice, that is also paragraph.
The legal notice will not extend your limitation, but if you say that what from what basis are you saying that it is still 2023?
Let's see in the paragraph 3 of that legal notice, it mentions that my order stated that we had approached you many times.
Your approach will not extend it.
Annexure 3 completion date is 2011-2020, the last order. That's all. I'm sure early principles know there's delay and there is no admission from the chief engineer, Your Lordship.
Where is the acknowledgement of liability?
There's no admission as such,
Is there an acknowledgement of liability?
the chief engineer.
Oh, that's all completion of work.
That will not, you go to the civil court. We'll close this. Same order. You are S Nath.
Yes.
You first title, bro. First title code, you know. R go with the S Sharma. You can first paragraph. Sub. Yes, we'll give you a liberty to go to civil court if in case it is permitted by law. Okay.
Oblige, Your Lordship.
44, we'll have the interim order extended. এখানে লো anybody পেটো হ্যাঁ ইয়ারে আর এখানে আছে এটা ওকে সেখানে আমরা পাবো সাইন ব্ল্যাক করে নাও